Good afternoon and welcome to DCR's crash course on the Land Use Review and Processing Timelines, Part 2. We're going to go ahead and get started with today's presentation. So we're going to start with the Land Use Review component. So just like as part of the temporary approval process, an applicant must undergo a pre-application review prior to filing an annual license application to engage in commercial cannabis activity. As part of the pre-application review, DCR will determine location compliance and eligibility. Compliance and eligibility are based on 4 major land use considerations for that commercial cannabis activity. The first is the eligibility requirements under Municipal Code Section 10403A3. We fulfill this process by the landowner attestation, which is the DCR LIC 40164 form. The landowner is attesting that none of the disqualifiers for the proposed location have been met. Therefore, DCR would be able to proceed forward and accept an application for that location. The remaining components are all tied to Municipal Code Section 105, which is the distancing and location requirements for commercial cannabis activities within the city of Los Angeles. So one of the things we're doing there is we're reviewing the distancing of the proposed location from sensitive uses that are identified under the municipal code. For retail storefronts, there's a number of sensitive uses that DCR has to take into consideration. For anything other than, for any commercial cannabis activity that does not include on-site retail sales, we're only worried about whether or not the proposed location is within 600 feet of a school for all of the application types that we currently accept. We have not begun accepting applications for the volatile manufacturing type. However, in addition to being 600 feet away from a school, volatile manufacturing applicants must also be at least 200 feet away from a residential use. We're also looking to make sure that the retail storefronts with on-site sales are at least 700 feet from other retail storefronts with on-site sales, either licensees or applicants that have paid the temporary approval application fee or business premises relocation fee. That's the point at which a buffer is created around a business that would have on-site sales. And then of course, the last piece is making sure that the zoning for the proposed business premises complies with the different requirements for the activities that would occur at the proposed location. So as part of the pre-application review process, applicants must make sure that they submit certain types of information for DCR to make these determinations. So one, we need to know what the proposed business premises location is. That information is input as part of the pre-application review record through the DCR licensing portal. The only document that we require to be uploaded as part of the pre-application review submission is the landowner attestation that relates to the location restrictions. So of course, the landlord or landowner is best situated to know whether or not the business premises has been the site of any unlicensed commercial cannabis activity or enforcement action for unlicensed commercial cannabis activity. And of course, they would know whether or not they as an owner would be precluded from leasing to a commercial cannabis business because of their relationship to the commercial cannabis industry or regulation thereof. The second piece is utilizing the proposed business premises address, and that's just focused on making sure that the location does comply with the zoning and distancing requirements under Section 105. As I mentioned previously, folks that are pursuing the retail storefront with on-site sales have to be at least 700 feet away from sensitive uses, which include schools, public parks, public libraries, alcoholism or drug abuse recovery or treatment facilities, daycare centers, and permanent supportive housing. In addition to being at least 700 feet away from those sensitive uses, the proposed location must also be 700 feet away from any other licensed retail storefront, licensee with on-site retail sales, or applicant for the retailer with on-site retail sales that has paid their temporary approval application fees or business premises relocation fees. So a buffer is created around a retail storefront business with on-site sales, the earlier of when a license has been issued, the temporary approval application fee has been paid, or the business premises relocation fee has been paid. So DCR can consider pre-application review records from multiple applicants at the same proposed location. However, the first applicant that successfully goes through the pre-application review process and then pays the application fee would basically create a buffer that would eliminate the other pre-application review records from consideration or any application that gets submitted after the fact for that specific location due to the buffering requirements. For all other activities that we currently accept applications for, they just have to be at least 600 feet away from schools. And then as I previously mentioned, we're not taking in these applications yet, but anybody who would be applying for the volatile manufacturing commercial cannabis license type would have to be at least 600 feet away from a school, as well as 200 feet away from a residentially zoned property. In order to determine whether or not a proposed business premises complies with the zoning and distancing requirements, we do rely upon the Department of City Planning's Zoning Information Map Access System, or ZEMAS. If you go to the ZEMAS website, which is zemas.lacity.org, you have the ability to enter the proposed business premises address and get information related to that proposed business premises, which includes the underlying zoning, what jurisdiction that proposed location is in, and information tied to the specific property that may also be helpful in filling out your project-specific description form, which we use for the environmental review. The ZEMAS also has a radius tool that you can utilize, which will create a buffer around the parcel so that you can see what's within either 600 feet of the parcel or 700 feet, depending on the activity types that you're applying for. So this is definitely one of the helpful tools in addition to the DCR licensing map, where we house the different sensitive use information. In terms of processing timelines, the pre-applications are definitely going to be processed within 30 days of the payment. And DCR will determine the location compliance. So once the applicant has submitted the pre-application record, within 10 days, DCR will issue an invoice for the fees. And then the applicant has 30 days to pay the invoice. And then within 30 days of the payment of that invoice, DCR will determine the location compliance or reach out to the applicant to request additional information. Sometimes when the parcel is within 700 feet of a buffer, 600 feet of a sensitive use, DCR has to reach out to the prospective applicant and ask for a proposed business premises diagram. As we're doing the measurements, some of the measurements are from the closest exterior wall of the commercial cannabis activity to either the property line for the parcel or to the closest exterior wall of the sensitive use. And in order to do more exact measurements, we do need the proposed business premises diagram so that we could determine where on the specific parcel we need to be measuring from. And if the pre-application review record is deemed eligible for further processing, then the prospective applicant has up to 1 year from the date that it's deemed eligible for further processing to submit an annual license or temporary approval application. Of course, with the phasing out of the temporary approval application process, folks that are new into our process will most likely be applying for an annual license. So the pre-application record processing timeframe is really just the prospective applicant submitting the record for DCR consideration, DCR issuing the invoice within 10 days, the applicant paying that invoice within 30 days, and then within 30 days of the payment of the invoice, DCR would review the record and determine location compliance. If the proposed business premises is deemed eligible for further processing, then the applicant has up to 1 year from that date to submit an application, whether it's an annual license application or a temporary approval application, depending on what's available at that time. And as I previously mentioned, retail storefront businesses with on-site sales are not considered a sensitive use, but they do create a 700-foot buffer from one another. The earlier of when the city issues a license to engage in on-site retail sales, or for when the temporary approval application or business premises relocation fees, whichever is applicable, is paid. And the payment of the applicable fees is one way to create the buffer. The other way to create the buffer would be a fee waiver is issued to the prospective applicant. For instance, DCR is providing fee waivers to phase 3 retail round 2 applicants. Therefore, once the record has been identified as a phase 3 retail round 2 applicant, and we see that the temporary approval application or annual application has been submitted, we would then go ahead and apply the fee waiver, at which point the fees are considered to be paid. Next, I'm going to hop into the annual license application processing timelines. For our purposes, the next set of slides are really going to be focused on the retail storefronts with on-site sales. And then once we're done going through that, I'll provide an overview of what the annual application processing timeline looks like for all other activities, because a lot of the processing is going to be similar, but once we've actually issued a notice of complete application, that's where the two processes will deviate. So an applicant that either has temporary approval or has submitted a pre-application review record that was deemed eligible for further processing may enter DCR's annual license application process. For businesses that had temporary approval and a legal business entity record, DCR opened up this process to those businesses on May 1st of 2023. DCR is in the process of establishing legal business entity records for businesses that have not already created their legal business entity record. And then from there, we'll be able to generate an annual license application for all of the other businesses in our pipeline. The annual license application is nested underneath the legal business entity record. And in order to make sure that the record types are assigned to the correct records and businesses, a legal business entity record does have to be created before an annual application can be created for that legal business entity. And next week on Tuesday, June 13th, we'll go more into depth about the record types and the modifications that are done and how those modification processes will work under this new annual license application and annual licensing process. So, if you haven't already marked your calendars, please mark your calendars for noon on Tuesday, June 13th. That's when we'll go into a deeper discussion on the modification process for annual licensing records and folks that get licenses through these processes. Once the applicant submitted the annual application, the applicant will receive an invoice, usually within 30 days. We do not have all of the records automated with invoices yet, because we do have a local jurisdiction assistance grant that is going to allow us to provide fee waivers to some general applicants and some social equity applicants that were already in the pipeline. And that's what that grant funding was utilized for. So we need to make a determination. What'll happen is when the annual license record is submitted, the fees will automatically be assessed, and then DCR staff will have to review the record to determine whether or not the record is eligible for a fee waiver. If the record's eligible for a fee waiver, the waiver will be applied directly to the record. If it's not eligible for a fee waiver, an invoice will be generated, and then the applicant will have 30 days to pay the invoice, or the application record will be deemed abandoned. Once the fees are paid, DCR will begin reviewing the annual application materials to determine whether or not they're complete. Once all of the documents and the payment have been submitted, the application will be deemed filed. If the documents are not complete, the DCR will reach out to the applicant, let them know what the deficiencies are, and then the applicant will have 30 days to correct those deficiencies and submit the updated information and pay any additional applicable re-review fees, or the annual or the application record will be deemed abandoned. It's going to be very important for folks to stick to these timelines, because now that DCR's vacancy rate has fallen below 20%, we are going to be mandating adherence to these timelines to make sure that we're able to provide timely service to all other applicants in our pipeline as required by the municipal code. Within 30 days of DCR sending the notification, the notice of complete application by email to the applicant, DCR will also be sending out an email to the closest neighborhood council, the relevant business improvement district, if one exists, and then the city council office where the business premises is situated. Within 10 days of the receipt of a notice of complete application, the applicant or their designated representative needs to reach out to their neighborhood council and offer to appear before the neighborhood council to address any questions about their specific application. The applicant or their designee will need to provide written evidence of the offer to appear to DCR. This requirement only applies to applications with on-site retail sales. Any applicant that does not have on-site retail sales is not required to reach out to the neighborhood council, offer to appear, nor will they be subject to a community meeting. DCR for these retails with on-site sales is required to conduct a community meeting. So once the application has been complete and you've received your notice of complete application, you will also be invoiced for the cost of conducting the community meeting. And those fees will have to be paid within 30 days of the date of the invoice. Failure to timely pay the fees will result in the abandonment of the application record. Within 45 days of sending the notice of complete application, DCR will conduct a community meeting to solicit public input on the retail storefront on-site sales application. Notice of that community meeting shall be provided at least 20 days prior to the date of the community meeting. DCR will have a standing calendar whereby applications that have been deemed complete and the notices of complete application have been sent by date certain will go to community meetings in a specific area planning commission geography on a date certain to make sure that we adhere to this 45-day timeline. Because we have to provide notice at least 20 days prior to that community meeting, there's going to be some overlap between when the applicant may pay the fees and when DCR has to provide notice. So ultimately, if we do provide notice and you fail to pay the fees, the record will be deemed abandoned and a community meeting will not be conducted for the application because it will no longer be before DCR because it was abandoned. If you do have to refile, then you'll have to start the annual application process all over again. And then lastly, within 90 days of the date we send the notice of complete application, DCR needs to either deny the issuance of the annual license without a hearing or make a recommendation to the commission to issue the annual license. The date the recommendation is submitted and transmitted for commission consideration is the date that we have to do within the 90 days. If DCR recommends approval of the application, the commission shall make the determination of whether or not to issue the annual license after it conducts a public hearing. And the notice of the hearing needs to be provided no earlier than 20 days prior to the date of the hearing. Again, the commission meets on a bi-monthly basis. And as we start getting into them hearing these application records and the DCR staff reports, we will get into a cadence where records that are deemed complete and notice has been sent by date certain that have gone through the community meetings will be then scheduled for a specific hearing date that will allow for us to adhere to this 20-day notice requirement. Now, I'm going to go back a couple of slides just to quickly run through this for all of the activity types other than the retail storefront. So for every other commercial cannabis activity, basically 1 through 5 are all of the same with the retail storefront on-site sales application type. The annual application needs to be submitted. The applicant needs to submit all of the applicable annual application information forms and documents to DCR. They have to pay the applicable fee. Once the fee is paid, DCR will determine if the annual application record is complete. If it's not complete, DCR will provide the applicant an opportunity to cure the deficiencies and resubmit the materials subject to the payment of any re-review fees. And then once all of the documents and payment are submitted, the annual application is deemed filed. Within 30 days of it being deemed filed, DCR is required to send a notice of complete application by email to the applicant. And then again, from that step, DCR will have 90 days to either deny the issuance of a license without a hearing or issue the annual license with no hearing. Only retail storefront businesses with on-site sales go through a community meeting process. Every other commercial cannabis activity, the annual license may be issued by the executive director once we've completed our review of the annual license application materials, completed the environmental document, and then made a recommendation to the director to either deny or to issue the annual license. Since in my capacity as assistant executive director, me and my team have the ability to deny the application prior to the submission of a DCR staff report. We're only going to be submitting staff reports with the recommendation to issue the annual license to the executive director. We will not be making recommendations to the executive director to deny the issuance of the license. There's no need to do that. And that will make the review process for our executive director easier because she'll only have to worry about reviewing records where we're making a recommendation to issue the annual license. So 1 through 5, provide notice within 30 days of a complete application by email to the applicant, and then within 90 days, either issue the annual license or deny the license with no hearing. So the next couple of slides are just a different graphical reflection of what I stated for the annual licensing process for the retail storefront activity. So I'm going to leave the slide up for a few seconds and then I'm just going to move on. We wanted to make it available with some color banding just so that applicants who look at the PDFs after the webinar have the opportunity to see it in a couple of different ways. I do want to remind folks that our final DCR crash course will be on Tuesday, June 13th at noon. We'll be talking about the modification request process and how modifications will have to be submitted against the new record types to effectuate those modifications. So please mark your calendar and RSVP for that event. For the DCR team, are we ready to hop into some of the questions?
We are. And I think you did such a thorough job in your presentation that there aren't a ton of questions, so feel free to answer at length. So I'll start with the first question from MS. And they ask if an existing medical marijuana dispensary is about to relocate its retail activity, but keep other activities parked at the original location, what should they do in regard to the 4013 form? Should they submit one overall for the original location and then begin relocation modification, or would a 4013 be required for the new locations? Can the findings exemptions from the existing work for the new location?
Hopefully MS is still following along with the webinar so that if I miss anything, they can ask the follow-up questions, but let me give it a shot. So the 4013 form is site specific, and we have to review the commercial cannabis activities that will be conducted at the location under an annual license. So if it's the intent of the business to get an annual license for the retail activity as well as the non-retail activities, and then relocate the annual license, all of the activities should be submitted on the 4013 form. As we're moving forward, it's important to note that the state has indicated that they treat annual licenses and temporary or provisional licenses differently. So the state has communicated to DCR that the process to relocate an annual license or to do ownership modifications will be easier once the annual license has been issued. So the business, depending on how ready they are to move forward in the annual licensing process or how ready they are to move forward with a modification to the new location, needs to take that into account. For the relocation component, if the activity has not received an annual license and a relocation mod is submitted, DCR will do the pre-application review to determine whether or not the proposed location complies with LAMC 105 and 104. If it does, then the applicant will have the ability to submit an annual application at the new location for the retail storefront, in this case, and submit a 4013 form for the retail storefront activity at the new proposed location. And that will be reviewed, and then DCR, once the application is complete, would do the community meeting and make the recommendations in compliance with the process. If an annual license has been issued, the commission has already adopted the finding to issue the annual license and adopted the corresponding environmental report, so that when that license gets relocated within the city, we can then look to see whether or not those environmental findings basically could be transferred to this new location, provided that it complies with 104 and 105. And then if it does, that component is already done. The annual license is now associated with that new location, which will make it easier for you to get an annual license at the state level for that location. And really all you would worry about at the local level would be getting your state annual license at the new location, meeting the permitting requirements and the health permit requirements at the new location, and then of course, submitting for your final inspection, and then getting your operating permit at the new location so that you can begin operations. So there's going to be inherent benefits for folks to see the annual application process through to annual licensure, because it will make some of the larger modifications, whether it's transferring the license to a different entity, transferring the license to a different location, a lot simpler both at the local and at the state levels, as opposed to having to restart the application process at the local and the state level for the new location and then go through the entire process before you're able to get your licenses.
Thank you, Jason. MS is also asking, understanding that the state can only issue annuals now, will applicants spend less time with the dual application process if they meet the upcoming temporary approval deadline, or does it not make a difference?
If the business is not positioned to get a state provisional license, it's not going to make a difference, because the applicant will have to meet the city's annual license application requirements and then have the city issue the annual license in order to comply with the state's requirement to have an adopted final environmental report for their activities. Because we can't finalize that report until whoever's making that discretionary decision adopts the draft findings that staff have provided. The kind of the critical thing there is, within the annual license application workflow, we have a kind of like a temporary approval process built into it, so that applicants that can demonstrate that they have a corresponding state provisional license, or they get their state annual license before they get their operating permit, could request temporary approval, go through the initial inspection process, be issued temporary approval, so that they could operate under temporary approval while they meet all of the permitting requirements to meet the final to pass a final inspection, and then get their operating permit for their annual license. So for folks that can't get the corresponding state license, temporary approval is not going to do anything for you, because you can't operate without the state license anyways. And you can't have a complete state annual application without the city annual license. So you and your client should take that into account.
Okay, the next question is also from MS. If there's an existing operational delivery license, but now want to use that same exact location and same exact entity for a retail lottery selectee, would DCR issue approval for a retail storefront? Please note that it will be for the entire premises, which is already occupied by the delivery license, and it will be the operator's intent to operate the delivery all the way to the point of approval of the retail storefront. Is it safe to assume that DCR will notify the storefront applicant and let them know that the storefront application is ready for approval, but that the delivery app will need to be abandoned first?
So it depends. The answer to the questions could be yes and yes. So the first question you'll have to respond to would be whether or not the business issued the delivery license is the same as the business that is applying for the retail storefront license. If it is, it's going to make it all the more easier to facilitate that, because we could assign the records to the same analyst, and then the business can work with the assigned analyst to outline the scenario to let them know, hey, I've got a license for delivery. This is what the business premises looks like. However, I also have the opportunity to go through the retail storefront on-site sales application process. I want to continue doing delivery and using that license. However, I plan to cancel that license as soon as I get my retail storefront license because it allows me to do on-site sales and off-site sales. So I won't need both licenses. You know, that can be worked out mechanically. The thing to also take into account is, are you going to be able to get a temporary approval and state provisional license for the retail storefront activity? If you are, then that's something that can be worked out in short order. If you're not, then you can continue to get, use the temporary approval for delivery, renew the temporary approval for delivery, but then you're going to have to pursue annual licenses for the retail storefront activity. So, you'll need to make sure that you're renewing both your temporary approval for delivery and making sure that you're continuing to move forward with the retail storefront activity so that you can do that transition sometime in the future. But it's something that can be worked out. If the delivery license is held by a different licensee, then, we would, of course, one, have to caveat the inspection to make sure that, it's accounted for that this licensee is operating. So there's going to be the presence of cannabis at the location, or that licensee would have to cease operations prior to DCR doing its inspection, because if they do pass the inspection and they're eligible for licensure, then it's going to be assumed that the entire business premises would be under the control of the retail storefront licensee, and the delivery license would have either been relocated or canceled to give the entire business premises to the retail storefront licensee. And I hope that provides some additional clarity.
Thanks, Jason. We're going to move on with Charles's question. He said he missed part 1, but has been working on a temporary approval for non-volatile for some time now. I'm seeing ANN 5000 forms requirement. What is that, and when will it be available?
So the ANN 5000 form should be available by next Friday. That form is really intended for businesses that are going directly into the annual application process that don't have existing temporary approval, so we didn't already migrate a record for them. The ANN 5000 form is a document that's combining the unique DCR forms that are going to be required for the annual application process into a single document. And what that's going to allow, both DCR and the applicant to do is that form will be linked. So when you enter the legal business entity name on page 1 of the form, it'll populate all of the other data fields in the forms that require the legal business entity. Same thing for like the BTRC number or the core DCR record number. The information that is duplicative across multiple forms will get populated based on what you put on the first form. So one, that should reduce errors that staff commonly find where the information is not consistent throughout the forms, and then we have to request an update to the form to make it consistent. And then 2, that's going to allow an applicant to submit a single complete form that has everything we need to review, so we can review it in one sitting. And then if there are corrections to individual forms that need to be made, we can communicate that to the applicant, and then the applicant can just use the a la carte forms to submit updated information to get to that complete application. So we may be able to consider previously completed temporary approval forms that have been submitted to the extent that the information is still relevant and it's consistent with the information on the record, and it's in the format we need it to be for the annual. For people that are coming into the annual process new, we will have them start using the new forms just because it's going to be cleaner for both the applicant as well as DCR staff to do the review and then do it in a timely manner.
Excuse me. The next question comes from Peter. Can you explain more about the 2027 change to social equity timelines?
Sure. So The 2027 change is just tied to DCR's authority to continue to renew temporary approval through the end of calendar year 2027. So that change applies to general applicants as well as social equity applicants. As part of the recent ordinance amendment, DCR proposed shifting the final inspection requirement to later in the process so that it didn't have to be complete before we make the recommendation to issue the annual license. We make the recommendation so that the applicant can have the documents to get their state annual and then start working with building and safety and public health and other agencies to get all their permits together so that they can meet the requirements for the final inspection and then of course request it. So the change was really, we pushed the time frame for renewing temporary approval 2 years beyond what the state has for their provisional licenses so that folks can get their local annual, their state annual, and they still have some time to meet building and safety's requirements, the public health requirements are, and continue to operate under the temporary approval before they have to get their operating permit. And that's really all the 2027 change was for, is to give folks a little bit more time to come into compliance with the different permitting requirements.
Okay, great. So the next question from Gregson. When will the annual record be created for those who didn't originally make the legal business entity record?
We're working with Excella to try to do that as soon as possible. Our goal is to have it done by next Friday. The first step is to actually stand up a legal business entity record for businesses within our pipeline. So we have to identify the ACA reference ID number for the entity, and that could be a corporation, it could be an LLC, it could be a sole proprietorship. So sole proprietors also need to have legal business entity records because in order to, effectively transfer a license to another individual or to a business entity, the LBER is going to be the mechanism to do that. So everybody needs to have one. And then the second piece is, once the LBERs have been established, it's, basically transitioning those TMP records into ANN records that would be housed under those LBERs. So, again, we're working with Excella. We're trying to do as much of the upfront work to establish the baseline records and then hand them off to individuals and business entities so that they can start to populate those records with the necessary documents that are required to make them active or get to a complete application.
Thank you, Jason. Our next question comes from MS. I thought there were amendments to the ordinance which now allow DCR to issue CEQA compliance through the TA app. Is that not a correct understanding?
It's a partial understanding. So there's two things that happen. Is the state has kind of raised the bar for the requirement to renew a provisional license on or after July 1st of 2023. So in order to renew a provisional license, the licensee needs to demonstrate that at a minimum, they have a notice of completion, which is CEQA speak for a draft environmental report. So we, DCR, will be issuing notices of completion to existing businesses with temporary approval so that they have the ability to renew their state provisional license after July 1st. That document is separate and apart from the final environmental report that'll have to either be adopted by the director or by the Cannabis Regulation Commission that once adopted has its own appeal process. It is not deemed final until that appeal process has run or that appeal period has run. And for the state's annual application process, they require a final environmental document. So that can only be obtained through the annual application process. We are in discussions with the state so that effectively on the annual apps, once we issue the notice of complete application, which will include the draft environmental document with the findings that have to be adopted, being able to submit those on behalf of our local applicant directly to the state so that the state can start to review these draft reports so that they can keep making sure that the applicant's state annual application moves forward, and then they can basically finalize it once the appeal period has been exhausted for that document, and then they don't have to start the review at that point. So hopefully that provides the clarity you were seeking.
Okay, our next question from Charles. What will temporary approval applications accomplish if a DCC on the state level won't issue licenses without an annual license?
That's exactly why the city is going to be phasing out the standalone temporary approval application process. And part of the amendments, so prior to the amendments, businesses had to receive temporary approval. Once they had temporary approval, they were eligible to start the environmental review. Once the environmental review was complete and we drafted an environmental document, then and only then could an annual application be submitted so that you could go through that process. Given the fact that the state's phasing out provisional licenses and you need to have an annual license to meet their annual license application requirements, temporary approval didn't make sense as a standalone process. So DCR worked with the council and the mayor to get these amendments adopted, which will allow folks to go directly from pre-application review into the annual application process to shorten the period of time and the holding costs associated with getting to a determination of whether or not you'll receive an annual license. What we've done is, as part of our annual license process and the processing of that record, created a mechanism for businesses to potentially get temporary approval once they've received their state annual license, to give them the opportunity to operate while they're working towards meeting the permitting requirements necessary for the final inspection and the issuance of an operating permit. So the temporary approval application process itself is going to have no benefit once the state phases out their provisional licenses. However, we will still take advantage of DCR's discretion to issue temporary approval if the applicant can get the corresponding state license and pass an initial inspection.
Our next question comes from MS. Do existing medical marijuana dispensaries also have to do community meetings for an annual license?
Yes. So all applicants for the retail storefront activity with on-site sales, regardless of how they came into the process, will have to go through a community meeting, as well as the non-storefront activities will have to go through the director for approval. And then the retail storefront with on-site sales will have to go to the Cannabis Regulation Commission, have the public hearing, and then go through the adoption process through them. The process is the same regardless of how an applicant came in. And that's one of the reasons why DCR is going to be changing its nomenclature to kind of focus on licensee. These are the folks that can operate. Applicant, these are the folks that are in the application process. And then prospective applicants, these are folks that are looking to submit an application but haven't yet submitted an application for consideration. So really, as we start to move forward in doing webinars, working with the public, working with stakeholders, we're going to get away from using phases, and we're going to focus on licensee, applicant, prospective applicant.
Thank you, Jason. The next question is also from MS. If an existing medical marijuana dispensary submits the 3 required ANN docs, plus the new ANN 5000 form by next Friday, approximately how long will it take DCR to issue an annual license?
We're hoping to have staff reports prepared for the director late summer for the non retail activities and delivery, and then to have recommendations going to the Cannabis Regulation Commission for the retail storefront on-site sales records in the fall. Because there's the requirement to get to a notice of complete application, there's the requirement for community meetings and notice, and then public hearings and notice. It will take longer for the retail storefront to be able to get to the point where an annual license is issued. The way we're going to address it for vertically integrated businesses like EMMDs is the draft environmental report will include both the retail and the non-retail activities, and the non-retail will be going to the director for adoption. And then, of course, the retail storefront will have a separate processing pipeline because of the community meetings and the public hearings. But, you know, a existing medical marijuana dispensary that gets everything in could be positioned to start receiving the annual licenses for the non-retail activities sometime in late summer. And, you know, provided that the community meeting fees are paid and the noticing fees and stuff get paid in a timely manner, there's going to be the opportunity to have the staff report transmitted to the Cannabis Regulation Commission by this fall.
Our next question comes from Anai. Where can I find the ANN 5000 form?
That form will be uploaded to the DCR website by next Friday, June 16th. So that form is really going to be intended for folks that are newly coming into the annual application process that don't have current individual a la carte versions of the forms already on their records.
This might be the last question. I'm not seeing anything else in the Q&A. This one comes from MS. Can any local CEQA exemption document be provided by DCR which does not need to go through an appeal process? Do you believe there will be eventually a local shortcut where sufficient CEQA docs for the purposes of receiving the state annual will be expeditiously issued by Los Angeles?
Good questions. So there's a couple of different ways we're tackling this. So for the first part, CEQA creates a pathway for an appeal process. So there's no workaround there's no pathway for DCR to adopt a CEQA, a categorical exemption for a project that doesn't allow for an appeal process. So what we'll be doing is for businesses that we believe qualify for a categorical exemption, once the decision maker makes the decision to adopt the environmental document and issue the annual license, we're going to file a notice of exemption with the county. And what that does is it shortens the appeal period from 180 days to 35 days. And there's a higher bar that an appellee would need to meet in order to justify why a categorical exemption doesn't necessarily apply for a project. So for phase 1 and phase 2 businesses that were operating before the regulatory regime was established and a license was required to engage in that activity, these businesses, from what I've seen, we're recommending categorical exemptions either based on a class 1 because it was an existing use or an existing facility, or the class 32 where it's an infill project. And, for our phase 3 retail round 1 folks, the round 2 folks, and the delivery applicants, the zoning and the distancing requirements by and large lend itself to be considered a class 32 for an infill project, because these businesses are going into a location that is zoned for commercial use where retail activities or delivery related activities would be allowed. So the activity types that are potentially more environmental intensive, like volatile manufacturing and cultivation, one, volatile manufacturing has never been made available, and then two, cultivation has not been available since 2018, and it was only available to folks that could demonstrate that they were engaged in the activity before DCR was even created. So again, that's why it lends itself to existing facility and infill project. The other piece of it is we are looking to utilize a portion of the LJAG funds to update the environmental document that the Department of City Planning had prepared prior to DCR coming into existence. City Planning was the lead agency developing the distancing requirements, the zoning requirements, and a lot of the different analysis that went into establishing the initial licensing regime for the city. They transmitted, I believe it was a negative declaration to the city council for adoption. And because the Adult Use of Marijuana Act created a statutory exemption that allowed municipalities to basically begin their licensing regime utilizing the statutory exemption as long as it's discretionary, the city council decided not to further consider the negative declaration, and they went with the statutory exemption. So we're hoping that the council will instruct city planning and DCR to update that document and then present it to the council for adoption, because that would then be an adopted environmental document that we could clear future licenses from. But that could be a year, 2 or 3 years away. In the meantime, the new ordinance does not require DCR to do the environmental report. It creates a pathway to allow the applicant to hire a consultant to prepare their own environmental report. And because that environmental report can be submitted as part of the annual application process, an applicant that goes through the pre-application review has a site that's eligible for further processing. That applicant could hire a consultant, develop the environmental report prior to submitting the application, prior to locking in a lease for the location. And then once they've got their complete environmental report, to the extent that it's saying categorical exemption, submit the application, submit the environmental report, DCR will review it. If we agree with the findings in the report, you can check the environmental box off, and then we're really looking at, do you have an executed lease, proposed premises diagram, attestations, indemnification agreement? Did you pay your fees? Now you have a complete annual application. We issue the notice of complete annual application, and we can move the record forward for further processing to either the director or the Cannabis Regulation Commission in community meetings, et cetera. So that's kind of the three-pronged approach for how we're trying to tackle CEQA and make this process as streamlined as possible for applicants and licensees.
We did have another question come in. It's coming from MS. I believe that the state accepts a notice of exemption from the local jurisdiction in order to approve the transition of a provisional license to an annual license. Please correct me if I'm wrong. If I am correct, will DCR be focusing on issuing notices of exemption ASAP?
The answer is yes, but in order to get to the notice of exemption, DCR staff prepare a staff report with the environmental analysis. And then that report plus the recommendation to issue the annual license has to go to the first level decision maker, the director or the Cannabis Regulation Commission. When the first level decision maker reviews the environmental analysis and the staff report with the recommendation to issue the annual license, they will have to review them in parallel and then make a decision as to whether or not they're going to adopt the environmental findings and issue the annual license. Once they've made that determination, DCR then can go to the county and file the notice of exemption paperwork, which will shorten the appeal process for that environmental document from 180 days down to 35 days. And at that point, the notice of exemption, the filing can be used to submit to the state so that they consider at least the environmental document adopted, and then it would be deemed filed once the appeal period has run its course. So we will be focused on filing notices of exemption with the county as soon as the first level decision maker adopts the environmental finding and the recommendation to issue an annual license. So somebody is going to have a fun time driving down to Norwalk on a regular basis to make sure that those NOEs get filed.
We do have some additional questions. This one also comes from MS. Would a thorough 4013 form and other equivalent state forms be sufficient as a self-created environmental report?
Possibly. Effectively, once we start to transmit DCR staff reports to the commission for adoption, and they're considering these environmental reports, there'll be a working template out there in the ether that an applicant could use as a framework to either work with a consultant to develop their own environmental report, or to have if they have a subject matter expert that understands CEQA and the requirements, utilize the 4013 form and the other state forms to basically draft their own environmental report that they could then submit as part of their annual application package. And DCR would then review the report in conjunction with the forms that we would review anyways to determine whether or not we agree with the environmental analysis. And, if we do, great. If we don't, there will be a conversation about where we may disagree or where we may need additional information.
Okay, we do have a question from Manahi, and she's or he is asking for clarification on what was stated regarding CEQA. Are you saying you can hire a CEQA consultant to provide an exemption to expedite the process, or is the 4013 form the same thing?
So the 4013 form is a requirement for the annual application process, no matter what. When you submit the 4013 form, DCR reviews the form and the information contained to draft its environmental report. You could complete the 4013 form and hire a consultant to do an analysis to determine whether or not they think you qualify for a categorical exemption, a negative declaration, a mitigated negative declaration, and they can prepare the report that you could submit to DCR with your 4013 form. And then we'll review the form and the environmental document. If we agree, we don't have to write a robust report. We just have to write a report that concurs with the environmental consultant's findings. So it'll expedite the review and the drafting of the environmental report that's necessary to get to a complete application. The ordinance previously required DCR to do the analysis and write the report. as part of the amendments that went into effect last Friday, now the applicant has the option to work directly with the CEQA consultant to have their consultant prepare the report and submit it to DCR for consideration. So yeah, you could at this point hire a CEQA consultant to draft your environmental report, which may include a categorical exemption finding to expedite the processing of your annual application. And you can submit that consultant report with your complete 4013 form as part of your annual application.
And then a question from MS. What is stopping DCR from already putting together the environmental report and beginning the county filing process?
So two pieces. So DCR is already putting together the environmental reports, and the notice of completion that we're going to be giving to the existing licensees to allow them to renew their provisionals is a notice of completion, which is the draft environmental report. We can't file with the county until the environmental report has been adopted and the first level discretionary body has adopted the environmental findings along with the discretionary action, which is the issuance of the annual license. So DCR cannot file a notice of exemption with the county until this, whichever decision-making body it is, the director or the commission, has adopted the environmental finding and adopted the recommendation to issue the annual license. At that point, a decision has been made, the document has been adopted by the quasi-judicial body, and then we can go and we can file with the county that the body has adopted a categorical exemption, therefore here's our notice of exemption.
Okay, you ready for the next one?
I think so.
Okay, this comes from Hanai. What credentials are required to be considered an environmental consultant, and do you have a list of approved firms?
These are great questions. To protect yourself as a business, qualified California environmental consultants that understand CEQA, which is the California Environmental Quality Act, would be a better environmental consultant than, say, somebody who is an environmental consultant out of South Carolina. What the Department of City Planning has dealt with is they used to have environmental consultants from out of state that aren't familiar with the requirements of CEQA, basically submitting environmental reports on behalf of their clients, which were either incomplete, they weren't correct, they didn't address all of the issues. So what they've done is they've established two benches of environmental consultants. There's an internal bench, which city agencies can utilize. And then there's the external bench that developers and other folks that are pursuing a discretionary action from city planning can utilize that have been pre-vetted. So what DCR is doing is, for our purposes, for overflow, we are utilizing city planning's internal bench of environmental consultants. So if we don't have staff capacity to review the 4013s and write the staff report, we can contract with an environmental consultant that already has a contract with the city to do the analysis and prepare the draft report for DCR's final review. There's nothing in the code that requires you to use an environmental consultant that is on the city's bench. We are going to be using firms that are pre-approved by the city. We will be posting the list of pre-approved firms on our website, and as well as providing the firms that have been contracted with to start working on applications in different geographic areas. But there's nothing that would preclude you from identifying your own environmental consultant and going with them. I would just caution you to make sure that they are familiar with California law and CEQA specifically, so that when they do prepare the report, it's less likely that there's going to be some type of fatal flaw in their analysis that's going to require you to go back to them and either do additional analysis or update the analysis. I hope that helps.
And then we have a question from MS. Will DCR charge additional review fees if an applicant used their own consultant?
That's a good question. There's different sets of fees. So there are fees associated with reviewing the annual license application materials, and the 4013 form is one of those materials, and that's baked into the annual license application fee. Separately, there's fees associated with preparing and doing the analysis for different environmental reports. So if an applicant used their own consultant, a report was prepared, we would review that report in the 4013 under the application license application fee. If we concur with the analysis and we believe we can use that consultant's report for our process, you wouldn't be charged the a la carte fee for the categorical exemption. So yes, if you use your own consultant, you would not necessarily be charged for the additional creation of the environmental report. But either way, we have to review it, and the review, whether we prepare the report or somebody else does, is already baked into the annual license application. I appreciate everybody taking time out of their day. Again, we will be doing another crash course on Tuesday, June 13th at noon. And then the following day, we have our standing monthly Q&A with me. So, you'll have opportunities next week to ask additional questions. We'll be covering the modification process on Tuesday. And then of course on Wednesday, we'll have the open-ended Q&A. So any questions that you may have or come about after this webinar or between now and next Wednesday, feel free to attend the Q&A on Wednesday and ask away. So I would like to thank everybody for attending, and we will get these materials posted to our website as soon as possible. Thanks, everybody. Bye.